Good afternoon and welcome to episode number 40 of At Your Service with Haber and Martinez. Believe it or not, we hit our 1 year anniversary. We just haven't done 52 shows. So
we have a life, Michael. They're not paying us the big bucks like they do on CNN and Fox.
Yeah, that's true. The episode has been entitled Snitches Get Stitches, or the pros and cons of cooperating with the government. We have an awful lot of cases that involve what we call substantial assistance or cooperation with the government, and this can cover a wide swath of activities and cases and information, although most commonly we see it in narcotics cases, but it has an awful lot to do with other types of offenses too, including organized crime. So we're gonna talk to you about the rules and the protocols. We're gonna give you some of the do's and don'ts and cans and can'ts, and we're going to talk about some of our own experiences with substantial assistance and cooperation, but we're also going to employ Hollywood. And if you saw the promo of today's show, I'm just going to run through these because I think that these are things that most of the audience will have seen at least some, if not all of. So for instance, let's think about Goodfellas, right? The main character, the narrator of Goodfellas, the character that Ray Liotta played was Henry Hill. And that's based on a true life story of an individual named Henry Hill, who was actually a mobster. He was what we might call a bad guy or a criminal who wound up snitching to work or to earn time off of his own sentence. So at the end of the movie, you see him testifying in open court against all of his former good fellas. So that's one example. Another example, interestingly different example, is Sean Penn's character, David Kleinfeld, in the movie Carlito's Way. He's becomes a kind of corrupt lawyer who steals $1 million from one of his clients, which was supposed to be used to bribe a jury, but which instead he put in his own pocket. And ultimately, because of death threats and everything that he knew was coming at him, he goes to the police and offers up his own client, Carlito Brigante, in order to save his own ass from prosecution and disbarment. You could think about The Matrix, the original movie, the first one, the one with Joe Pantoliano, who plays the character Cypher. And he makes a deal with the agents to turn over Morpheus, Lawrence Fishburne's character, so as to get a benefit. He wants himself removed from the real world and reinserted into the Matrix, right? So that's kind of a payoff. It's a CI in a way who's being paid for his information. Danny DeVito's character, Sid Hudgens in LA Confidential. He's a journalist, and he basically pays a detective to make certain busts, which he becomes aware of because of his journalism, so as to promote his own brand and his own show. Frank Serpico, Al Pacino in the movie Serpico. He's a police officer who goes undercover to dig up dirt on his own department. Another undercover police officer would be Johnny Depp, aka Joe Pistone, in Donnie Brasco. In that case, he's an undercover FBI agent who infiltrates the mafia. Then the final two that I'll bring up are the all-time classic of The Godfather 2. We have two characters in The Godfather 2 who are both, in a way, rats. One would be Frank Pantangeli. He winds up in federal custody, and he's supposed to give testimony against Michael Corleone. And you may recall, after he sees his brother in the Senate chambers, he gets up there and says, well, the FBI wanted me to say Michael Corleone this and Michael Corleone that, so I told them what they want to hear, right? He was a informant witness. He was a captain or a capo in the Corleone crime family. He was trying to work off his own sentence for his own crimes by testifying against Corleone. Of course, that was after Corleone tried to have him killed. And then, of course, there's Fredo Corleone, who, while not working with the government, was a rat against the family because he provided information to Hyman Roth's organization against his brother Michael so that he could get a little something for himself and earn his respect. And then the final one that I'll bring up is The Departed. And you have three different types of informants in The Departed. the main character, Jack Nicholson, who plays Frank Costello, he's actually a government informant for the FBI. And the deal that he cut with the FBI is he provides them with information so that they can make federal arrests in exchange for taking out his competition and allowing him to continue his criminal enterprise, which is something Ed and I are going to talk very heavily about. But you also have two more in that show. You've got Leonardo DiCaprio's character, which is Billy Costigan, who is a undercover police officer who infiltrates the mob crew, kind of like in Donnie Brasco, Johnny Depp's character. And then you have the reverse character, which is Matt Damon's character, Colin Sullivan, who's a sergeant in the state police who's actually on the payroll of the mob guy. And so he's a double agent misdirecting the police so as to gain benefit with his mob controllers and continue to live the lifestyle that he loves. So now that I've droned on for a solid 5 minutes, I apologize, but this ought to give you some idea of the types of things that we're going to be talking about today. So I think before we get started and I turn it over to Ed for a minute, let me just say that y'all know that if you've watched this show or you know either of us, I've been a defense attorney since day one. I've never worked the other side of the aisle, whereas Ed has. Ed was a prosecutor in the Dade County State Attorney's Office, and for a period of time, he was assigned to the narcotics division. So cooperation or substantial assistance played a very key role in that portion of Ed's professional career over at the state attorney's office. So what you're going to get from both of us are a lot of the do's and the don'ts and the cans and the can'ts and the shoulds and the shouldn'ts and the pros and the cons. But on my end, you'll get it more from the defense perspective, whereas Ed can give you both the defense perspective, because he's been doing that now for about 20 years, plus the perspective of law enforcement. In other words, how would the prosecutor handle this? What happens when the cops come to the prosecutor with a case involving a confidential source or a confidential informant? What do they do? What are they supposed to do? How does a narcotics prosecutor advise the police to proceed in different types of circumstances? It's really interesting and it's intricate, but let's go back and start with the initial premise: snitches get stitches. How did that come to be? How did that aphorism turn up in our world, Ed? Tell the audience.
Well, I think. Look, let's talk about that right now. That is something that was much more prevalent probably 20, 30 years ago. It was, you knew back in the day, mainly because law enforcement wasn't going to get involved. Let's be honest. That if you snitched, if you were part of a mob, part of a gang, part of a criminal enterprise, anything you did, and you snitched on your guys, then your guys would take it out on you sooner or later. And back then, back in the day, the cops would turn their back because they really didn't care. I mean, even to this day, there is a saying: not all officers, but some officers, when they get to the scene of a rival gang member that's been shot and killed by another gang, they refer to that body sometimes as, or the shooting, they refer to it as a shooting into occupied clothing, meaning they really don't care. And that's the truth. Look, you can say what you want. Don't kill the messenger. I'm not saying it's right, but that's what they do. So that was much more prevalent back in the day. Not so much today. I've had a lot of CIs, Michael, when I was in the office. Nobody ever was chased. Nobody ever was sought after. To be honest with you, the vast majority of the times when we had somebody that we arrested, they knew who the snitch was. They knew immediately who it was. Because they knew this is the only guy that could have ratted me out, and they know exactly who the guy is, or woman, as it may be. So that's the first thing I want to lay to rest as a myth.
But there is some truth to the expression in that some people do wind up in actual danger, right? Let's take Henry Hill. Absolutely. Let's take Henry Hill, for example, right? That's a true story.
That's where we get into the intricacies. Now, when we look at
so that's not, again, we're talking about a Hollywood movie, but it's based on a true story, and it's based on many a true story if you want to extrapolate it, right? So here's a guy who's actually in real danger. Right, he's provided assistance that could result in his.
Well, yeah, Henry Hill was dealing with some very bad guys.
Now, well, and you could make the same argument for the movie Serpico, right? Because even though he wasn't going after mob figures or drug dealers, he was going after something arguably far more dangerous. That is the police. He was looking to expose corruption in the police department, and so his life was truly in danger because, unlike Henry, unlike a unknown character, he's actually known to the people, right? They know exactly who he is. So
Right.
if you go to the Johnny Depp movie, Donnie Brasco, right? They didn't know that Donnie Brasco was Joe Pistone. Now, ultimately, they would find that out. That's also based on a true story, I believe.
It is. Yes,
Ultimately,
it is. Absolutely.
ultimately they would find that out because he has to come testify against them, right? So this guy may wind up actually having to relocate as well.
Well, actually,
Because how
right, and the guy who was the most in danger there was Al Pacino's character. I believe they
Lefty,
even killed him. They killed him because he's the one that brought him into the organization. He's the one who vouched, and that
right?
was what's really important. One of the things that people need to understand when we talk
That's
about
because he's a friend of ours, not a friend of mine.
right, it's when we talk about snitches get stitches. The ones that really need to worry are the ones. If you're a snitch, if you're a CI, that the people that you're going after are number one are very very bad people, and number two they realize that killing you would put
Kill the
law
case.
enforcement in a situation where they would see it as a shooting into occupied clothing. If you know that you would be considered occupied clothing, then you're in severe danger. So for example, Mike, one of the things we did when we were in narcotics, we would discuss using CIs, and there were many reasons why we would not use them. One of them could be that we said, no, this person, if he gets us that target, is definitely going to be in serious danger. And we would specifically choose not to use him. Or if we could insulate them, we would insulate them. And that might be a good maybe segue to tell you how we would insulate.
Well, let's get there in a minute because we'll talk
Okay.
about tactics shortly. But
Okay.
I want to.
Well, that's one thing that we would consider is this person really that much in danger, or is he just going after some low level drug dealers? They're not going to kill him. They're just going to be upset at him. And maybe if he saw him in a club one night, he might beat his butt, but he's not going to really shoot him or kill him. And so we take those things into account.
Let's start with an initial discussion of why it is that people even become confidential informants, because it very few people, I guess, just wake up and say, you know what I'm going to do? I'm going to be a CI. Most people,
they're not qualified. Most people are not qualified to be a CI.
I would say the vast majority of confidential informants are people who have been arrested or have been targeted by law enforcement and have made a calculated decision that it is better to cooperate with law enforcement and get a reduced sentence than to fight the case and get sentenced. Now, that said, there are many people who take the position, I don't care if they give me anything. And I will tell you guys a story about a client I had who had that position. He basically looked at the federal government and said, I know I'm getting 5 years. I'll do my 5 years and I'll be done. That's it. You get nothing else from me. Take me to jail, basically.
Yeah,
so,
I've had those. I've had those on both sides.
Most of the time, it's people who are trying to work off their own sentence. But there are other categories, too. There are paid informants. There are people who are just entrenched in the underbelly of society. They have contacts with nefarious sorts, and they figure they can go to the police and make money because the DEA, particularly, but many other agencies, including local ones, will pay very good money for information that pans out. Kind of like, think about it in a way, kind of like Crime Stoppers, right? You hear them all the time. $25,000 reward for information about blah, blah, blah. Well, it's kind of like that, except instead of the police putting out an advertisement looking for information on a specific case, these are people who have all kinds of information that they want to sell. And they go to the police and try and broker it. And sometimes they get paid flat fees for cases, or they get percentages of forfeitures, or they get paid a flat rate per kilo of cocaine. There's all sorts of different
the flat
calculuses.
Rate, the flat rate payment was much more prevalent back, even before I got started, when the drugs were really, really prevalent in Miami. And some, it was a war, and they needed to do whatever they could. But today, the vast majority of CIs that are getting paid are a percentage of forfeitures.
And there's one other there's one other category that I can think of. Maybe you can think of more, but the other category is what I call the Dudley Do-Right citizen. And those are the wannabe cops, right? They're not looking for money. They're not looking to work off a case. They just want to play policeman. So they get to hang out with the cops. They get to go into the back room in the police station where most of us are not permitted to go. They get to go into debriefings, and they get to, it's like Halloween for them. They get to play police officer.
Yes,
So apart,
that is another option, but those rarely, if ever, happen. To be honest with you, Mike, any prosecutor who uses someone like that is either a very young and inexperienced prosecutor, um, or really doesn't understand what they're doing, because those are dangerous. Believe it or not, if you stop and think about it for a second, those are CIs that we wouldn't want to work with for many reasons. Okay. First of all, let's go back to before we keep going. Remember I said some people just don't qualify for being a CI. This is one example. What qualifies you as a CI? Well, believe it or not, the best CIs are the ones that were the biggest criminals, because nobody's going to sell drugs to me. Nobody's going to sell drugs to you, Mike. No disrespect. You don't look like a hardened criminal. I don't look like one. Most of the times, as soon as I put on sunglasses, I look like a narc. So they're not going to sell to us. And as much as I grew up with some very nefarious individuals, I still have a lifestyle that it's be hard for me to get into that character and sell it. Whereas these guys, it is who they are. They're genuine. They will be
but
sold to. They will be talked to.
I think that depends on what it is that the CI is going to be doing. So why don't we talk about that? Because there are some confidential informants that do nothing but provide information, and they don't have to present. It makes no difference.
Well, but those are
others.
Those are
we're gonna get there. So, and then there are others who are proactive and actually going out and conducting transactions like you're talking about. So let's distinguish between those two. I'll let you take that.
Okay, so technically, and I know this is technical stuff, but some of you might be interested. Technically, somebody that gives police information is a confidential source. Confidential source is different from a confidential informant in a very distinct way, that officers still have to independently corroborate what they're told. Whereas if it's a confidential informant, the informant goes in, sees what he says, and depending on whether we've used him in the past and he was reliable, we can rely on what he says as if he were a cop.
And so one of the games that they like to play is they like to label a confidential informant a confidential source. And they like to say, this is somebody who we've worked with before, who has provided us with reliable information, so we know we can trust it now, even though they don't send him in to do anything proactive.
Right. And they say, look, but they still have to corroborate independently.
And then with the Dudley Do Rights, they do the same thing, and they use what they call an anonymous source, and they never list Dudley Do Right, or they don't list their prior confidential informant, because they rely under the allegation that, we don't know who it is. It was just some random person that called us, and we went and verified what they told us, and that's what we acted on.
And that is the scariest one. Another one they like to use is the Crime Stoppers tip line. Now, listen, let's be clear. We've said this 1,000 times, but we have to reiterate it. Most of the cops that I have ever worked with are very good cops, honorable and honest and good guys that really just want to do the right thing. Okay. But like everything else in life, there's some that are bad apples. And the problem with that anonymous source, or especially if it's a Crime Stoppers tip line, is that those Crime Stoppers tip lines, because of the need for it to be anonymous, are not disclosed ever. They will not be disclosed, and there's no way for us as defense attorneys to get that disclosed. We would need a whistleblower. We would need a cop on the unit to say, listen, that's bullshit. It wasn't a confidential tip from the tip line. We got it from some guy that we busted buying crack. Otherwise, there's no way to know. But those are separate and aside, because, I mean, what can we do with that, Mike? It is what it is. If we don't get a whistleblower, we're screwed. But if it's a Crime Stoppers tip, or some guy who told them something because they arrested him on the side of the road, for example, then that's a confidential source, and the cops would still have to independently corroborate what they were told. So if the guy says, look, this guy's selling cocaine out of his house, they would at least have to watch or see, the officers, they would have to at least see one by that they can say, we saw what really was very, very suspicious in our training and experience, looked exactly like a drug deal, looked exactly like a cocaine buy.
So that you guys understand the why of this. Why is any of this important? I have 3 words. It's a 3-word answer. The Sixth Amendment. according to the Sixth Amendment, you have the right to confront your accusers. So the police may arrest you, but that doesn't make them your accuser. Your accuser is the person who brought the matter to the attention of law enforcement. So, for example, let's take a non-CI case. Let's just talk about a domestic violence case, which we've done many times on this show. If Ed and I are live together, we're domestic partners, whatever, and we have an argument, we have a fight, one of us gets arrested, the one who gets arrested has the right to have the other one appear in court and testify. And if I get arrested, Ed does not show up in court and testify, it doesn't matter what the police say or saw. That case is gone. Correct. Now, there are exceptions. Yes, there is that one blue moon circumstance where they may be able to proceed with excited utterances and spontaneous statements and other corroborating evidence. There may be video, whatever. But overall, I have the right to confront my accuser. Because what happens if I take the witness stand and say, no, I smacked Ed, but I had to because he was beating on me. I didn't do it. I wasn't the initiator. He was. And I'm going to claim self-defense. So that's one of the main reasons in CI cases that they have to present this Sixth Amendment witness is the government needs to be able to get around a claim of entrapment. And there's no way that they can do that without putting the actual person who created the situation on the stand to affirmatively disprove that you were entrapped and that you actually did this out of free will.
And let me explain this a little so you guys can see the pattern and exactly why confidential sources cops have to independently corroborate. And if you're a prosecutor, you want them to do it, and a confidential informant not. So confidential source technically should not be your accuser. He should be the guy that alerted the cops. The only important thing is it legitimate enough to give the cops a legitimate purpose?
Right.
Being there?
So that's confidential source, right?
That's a source.
Right.
The cops have to see what you did, so they are become now your accusers.
Right.
Now,
so the confidential source is simply providing information that the police then verify and act upon. That's a very different story than the confidential informant who is proactive,
right? And
he or she is the one that's actually conducting the transaction.
And here is why the confidential informant can be used as a source, as your accuser. And what steps did we do? Why didn't everybody qualify? So what steps did we do? For example, if you hire somebody who knows from the other side what those confidential informants need to do, those officers need to verify that person never spoke to the target. Well, let's say Michael is a big time drug dealer that we're coming after, and we want to get a warrant on Michael. And we send in the confidential informant to make a buy so we can get a warrant. Well, since he's a confidential informant, we have to have access to his cell phone. We have to see from his cell phone records. He has to document every single time he spoke to Michael. Now, here's a myth. We don't have to listen every single time he speaks to Michael. That's a myth. The cops don't have to listen. But what the cops do have to know is he has to tell the cops every single time in a detailed report, every single time he spoke to Michael and what they spoke about. If a good defense attorney can get those phone records and see that there's a missing call or two, now that may lead to a question of whether there was an entrapment. You can't do that with a source because we don't have access to his phone records when we're prosecutors or cops. He's just some guy that gave us some info. So you need to independently corroborate. Confidential informant works hand in hand with the cops. They see each other on a very regular basis. The cops have to give them, believe it or not, Michael, the cops have to give them instructions on how to avoid entrapment. If a cop testifies in open court or the CI says, no, I was never told how to avoid entrapment, that could lead to an entrapment instruction to the jury. So the confidential informant is really, when it's done correctly and prepped correctly by the state, mainly I blame the prosecutors if it's not done because that was my job, right? Can't expect the cops to know the law. They do the best they can, but they're cops. We're the ones who went to law school. I'm the narcotics prosecutor. So I would have to make sure that this guy was trained right. And so the other thing, what qualifies him, for example, how about a guy who's very seriously addicted to drugs, Michael? Well, we can't trust that CI because he might do something just to make money or to get off from his addiction, but he's still out there buying and selling drugs on his own. That becomes a very bad witness when a defense attorney represents our target. So there is a whole real detailed situation of what makes the difference between the two. And confidential sources, short answer, don't mean shit. Confidential informants have got to be very controlled and detailed because they are basically another cop. And of course, they're the accuser. That's
By the
why.
way, you actually mentioned something that I want to highlight right now. We've talked about how the Constitution applies to the government. It does not apply to private persons. So if Ed and I are roommates and I have no authority to enter Ed's room, but I go in when he's not home and I jimmy his lock and I find drugs or body parts or, you know, a young girl tied up in a basement corner somewhere, I can call the police and turn that over, and there is no constitutional violation. Now, Ed may be able to sue me, but that evidence is not going to be excluded. A confidential informant is a de facto government agent. They are treated as if they are a cop. They are not deputized. They do not have badges and guns. They've not graduated the police academy. But for constitutional purposes, they are law enforcement officers.
Correct.
So the Constitution very much applies to confidential informants. So what Ed was talking about presumes that you've got a conscientious prosecutor working on the case. So let me give you a little story. There's basically two different levels of law enforcement that we have to deal with. One is the federal government, and the other is state or municipal law enforcement. I don't think I've ever been involved in a federal criminal case where a assistant United States attorney was not fully involved from start to finish in every aspect of the investigation. That's just the way the feds operate across the board. I don't care if it's the FBI, the DEA, ICE, whoever. They all work hand in hand with the assistant United States attorney for the reason that Ed just said. They may be very well trained. A lot of them are lawyers, in fact. The law enforcement agents are lawyers by training, many of them. But either way, that's not the issue. The issue is the feds don't take chances. They take their time, but they don't take chances. The state,
plus remember, in the feds, every case in the feds, you are, as a prosecutor, you are responsible for that case. It's your case from start to finish before anybody gets arrested, because they do indictments. This is why one of the reasons when people ask me, well, Ed, what's the difference between somebody who was just a regular pit prosecutor and somebody who was in a special unit like I was in narcotics and economic crimes? Well, when you're in special units, you're more like a fed. The cases that I had in my unit were my cases. It was my responsibility. So I didn't want to look stupid. I wasn't going to violate somebody's rights, because at the end of the day, it's coming back to me. I can't point the finger at the cop and say, well, he made a probable cause arrest. No, he did not. We were involved in it.
Now, that's assuming that you are, because let's go to the second tier, which is state. In a perfect world, when things are done by the book and by protocol, that's exactly what happens. Narcotics officers who are working narcotics leads in narcotics cases deal with narcotics prosecutors, start to finish. And if you have that happening and you have a conscientious and ethical prosecutor, then they're going to steer the ship appropriately. Remember, the federal agents are and this is not in any way meant to disparage local law enforcement. It's just a fact. The feds tend to be highly trained in all aspects, far superior than state. That doesn't mean that there are not some extremely excellent and experienced state agents that are even better than some federal agents.
That is correct.
It's just to say the vast majority of the feds are more highly trained than state officers. That said, not every state officer goes through the assistant state attorney, even in felony cases. There are a lot of cops that run their CIs rogue. They do what they do. Maybe they go through a supervisor in their department. Maybe they don't. But either way, sometimes they just slop a pile of crap on a prosecutor's desk when they're ready to make an arrest, and all of that legwork has already been done. Maybe it's been done properly if they followed protocols. Maybe it hasn't. I've certainly had cases where I've represented people that the prosecutor did not know a damn thing about the case until it was dropped off into the prosecutor's lap.
Oh, yeah.
Cops literally made an arrest, booked the guy into the jail, and then the prosecutor all of a sudden is handed off a case with a confidential informant that they never knew anything about.
Correct. And I can say this: when I was at the office, which I left in 2004, 2005, when I was with the office, every narcotics like trafficking case, every trafficking case came through our unit. We reviewed it all, and then if it was a small case or if there were some problems with it, because again, like you said, sometimes these cops do it on their own, then we would kick it to the pits. Because why? Because the prosecutors in the pits are learning about a lot of different cases, and this is a case for them to learn on. It's either a loser or it's a very small fish, and it's not something that our narcotics prosecutor is going to have enough time to work. But we would have to try and save some of those. Believe me, Mike, I can tell you some horror stories of stuff that I have seen. I can tell you this: on more than one occasion, when I first got into the unit, right, cases I didn't handle before they got sent to the pits, I would have prosecutors come in on the day of trial. A lot of judges want to argue motions to suppress right before we pick a jury, and they'd come in the day before on a Friday.
So ridiculous.
Well, that's a show for another time. But yeah, so they would come in like on a Wednesday or a Thursday. Oh, I got to argue this motion on Monday. Okay, what do you got? And I'd start looking at the motion, and I'd look at the warrant. And before I would even look at the warrant, I could look at the motion, and I could say, is this true, what the facts are? And she'd say, yeah. I'm not going to say which departments back then, but I could narrow it down to 3 departments usually that always screwed it up. Oh, I'm not kidding. The prosecutors would laugh because they're young. They'd be like, how did you know? I'm like, I'm in narcotics, man. I know who you – I can just tell by reading this stupidity. You're screwed. You're screwed because they screwed it up. So sometimes we'd have to try and save these cases, but there's not much I can do if they screw it up when I was a prosecutor.
I don't want to go too deep into the rabbit hole, but let's just say that there are a litany of protocols that are in place for proper handling and documenting of confidential informants.
There are so many. It would take us 2 shows to cover it.
But what's important for you guys to know is if you have a case that involves a confidential informant, you need a lawyer who understands the rules, the policies, and the protocols inside and out. Because if they fail to follow protocol, that's where you wind up with a defense. Constitutional, whether it's entrapment, whether it's Sixth Amendment, whether it's who knows what. That's where it's going to come. But it's not going to come because you hired a traffic ticket lawyer to handle a trafficking case. That's not going to happen more than likely. No. So without going into all those, let's talk about like an example of how the cops play cutesy with this, right?
Okay, I can give you a real world example. Or do you have one? Is that what?
Well, I was just going to give up. You can give a real world, but let me give the idea. I'm going to give the concept to the folks, and then you can give them a real world one. So let's say that I am a guy who gets popped by an officer for a drug charge, and the cop torques me and says, you know what? You seem like a decent guy. I don't want to have to take you to jail. I don't want to have to, ruin your life. I'm willing to cut you some slack, but you're going to have to do something for me. I need you to wear a wire and go make a purchase for me from your drug dealer so that I can then arrest that person. But rather than writing me up as a confidential informant, rather than documenting any of it, rather than ever arresting me, rather than doing anything, rather than ever picking up the phone and calling an assistant state attorney, this police officer wires me up, sends me in, stays outside, does his surveillance. I go in and make a purchase, bring it out to him. He's happy, and he says to me, all right, here's what we're going to do. You're going to call me in a week, and we're going to do this again. Only this time when we do it, I'm going to come in with you. I'm going to be dressed in street clothes. You're going to call me your cousin or your buddy or whatever, and you're going to introduce me to the guy, and we're going to do another deal with the 3 of us so that he gets comfortable with me. And then I'm going to go back and do a 3rd or a 4th buy by myself without you. They never document the first transaction that I just went and did solo at their direction. They never document the second transaction where they went in with me. They only document the 3rd or 4th transaction. Now, there may have to be explanation later as to how they got this information, but now all of a sudden, I'm not critical to that case anymore, especially if they don't charge the guy with that charge, because they don't have to prove the case that I set up because they have an independent transaction with that undercover officer directly. So now the officer goes in and he's wearing his own wire, and he's got the drug dealer on audio and video conducting a hand-to-hand transaction with him. He used marked money to pay for the drugs. He brings the drugs out. He puts them right in evidence, sends the takedown team in, and they recover the marked funds. That's one of the little tricky, sneaky type things that law enforcement can do. This is not good.
I take offense to the charged word sneaky because I did that as a prosecutor because that's completely legal.
I didn't say it's illegal. I said it's sneaky.
It's completely legal, and that's one of the ways that we would get CIs out of the loop. That's one of the ways that we would get CIs. For example, suppose we had a CI that, you know what, we weren't 100% positive that this guy was not somehow, some way going to screw it up down the road. Either he was 2 brain cells from a talking monkey, or he was a drug addict, or something. And we're like, I can't put this guy on the stand. I'm not going to rely on this idiot. So we would literally meet and say, look, the only way we're going to do this is you got to get this guy to convince this guy to trust you, because you're going to have to go in and do the by yourself. Now, here's a couple of cool things I want to bring up in that scenario so everybody understands. Number one, if you were arrested for a misdemeanor, the cop can do that. He can literally do that.
And the reason for that is real simple. On almost all misdemeanors, there are some where there's no discretion. But the vast majority of misdemeanors, law enforcement has the discretion to either take you into custody or to issue what's called a paper arrest. They call it a PTA, a promise to appear, or an NTA, a notice to appear. And basically it looks and reads like a traffic ticket, or it could be written up on an A form. It doesn't really matter. But whatever it is, they just hand you a piece of paper and they say, be ready for a court notice in the mail, and that's it. Right. They don't book you into the jail.
If it's a felony,
some misdemeanors they have to book you into the jail, even though it's a misdemeanor. Right. For example, domestic battery.
Right. But if it's a felony, let's not go down that rabbit hole. If it's a felony, they have to get permission from a prosecutor. So they would have to call. So again,
right, they have. Well, wait, hang on. So the folks understand. What he means is, if you get arrested for a felony, the police have no discretion but to arrest you. In the event of a narcotics case or a substantial assistance or cooperation case, they can stop before they take you to the jail, reach out to an assistant state attorney, and then seek authorization to either not book you or to hold your arrest form in abeyance pending cooperation, or to somehow or another work it out so that you don't get booked. But I think what Ed will tell you is the better practice is to book you in the jail. And the reason for that is it gives credibility to the officers later against an entrapment defense. In other words, it shows that they acted legitimately. They didn't give preferential treatment to a guy right out of the gate. They treated him like everyone else, and then his cooperation pulled him out of the queue and put him into the specialized staff of somebody who might, not definitely will, but might inure some benefit as a result of his or her cooperation.
So let me give you a quick scenario. Suppose a cop calls me, he says, Ed, we just busted a guy with crystal meth. Okay, great. Or fentanyl. Great. But listen, he says his supplier is only here like 2 or 3 times a year. He stocks up. He's got a trafficking amount on him, but it's because he says he has to buy so much from his supplier because the guy's from out of town, out of the state, out of the country, whatever the case may be is. He doesn't know when he's leaving. He doesn't know when he's coming back. But we know right now he's staying at the Hard Rock Hotel. All right. I'd say, okay, I give him authority. You got to get a police case number right now, but I give you authority not to arrest him. Get him wired, read him, talk to him, train him, tell him what he's got to do, and go straight to the Eden Rock and see if you can finagle to get a couple more, more crystal meth or whatever it is, because we're on a time crunch, right? That's just one example. Again, we could go for days on all the examples, but that's one of the examples where they would get permission, but they have to get permission from an ASA, because now that person who committed a felony is actually become part of an ongoing investigation, and he's now become a cooperating witness with the state, so we can do it that way. Otherwise, they have to arrest. Let me give you a real-world example of how they get cute sometimes when they're trying to get a warrant. So when I was a prosecutor, I had a guy who's now a lieutenant at the police department. Great guy. He did not participate in these shenanigans. I knew shenanigans were going up because when he brought me the warrant, I could just tell by the look on his face that he knew that I was going to be pissed, and he was hiding something because he was terrified to tell me what he saw with his own eyes. So long story short, they said that they saw this guy. They followed him. They saw him do a hand-to-hand at the door, and before he closed the door, they rushed the door. So when they saw him do a drug deal, it wasn't with a confidential informant, it wasn't with a CI, but they saw the drug deal going on, and they pushed their way through. One of the things cops can do is what's called a protective sweep, which means they're allowed to go in and make sure nobody else is in the house for danger. So they're not allowed to look in drawers or anything like that, but they can search for.
What about little teeny people?
Correct. I'm looking at this and I notice that they brought in a dog to do a protective sweep, which is very odd. They rarely bring in a canine guard dog, attack dog. Narcotics units don't have canine attack dogs, but you know what narcotics units do have? What kind of canines do they have, Mike? Drug dogs.
Detecting dogs.
So I said to him, why did you guys bring a dog? Did you guys call out for a special canine to come out? And he wouldn't answer the question. So I knew exactly what it was. They brought in a drug dog, but they claimed that they found all the cocaine in a locked room. That was wrong. That's them playing little games. They brought in a drug dog, said that they didn't found the drugs and took it to get a warrant. That's how they play the little games. The only reason I could tell, Mike, was because I was a narcotics prosecutor. And by reading that affidavit, I knew it just didn't make any sense to me. And this is why, like you were saying earlier, when you're going to hire somebody to do these things, if you get caught up in a situation where you're dealing with drugs, narcotics, trafficking weight, CIs, there is a wealth of information that you need to make sure you get somebody who knows what they're looking at, because they will play these games. There's no doubt. Some cops are bad. Look, this cop was in a bad unit. He's a great cop. He's a wonderful human being and one of the best cops I ever worked with as far as being honorable and honest. That man is honest. He will look me in the eye and say, many times said, Ed, I didn't think I had enough probable cause. I know the guy did it, but I didn't have enough probable cause, so I had to let him go. That's what a good cop does. So, but he was stuck in a bad unit.
So, there's a lot of other things we can run into with CIs, but one of the things I want to touch on is the importance of a CI. So, if the CI is truly integral to the case, if he's necessary or she's necessary for the government to prove the case, as a defense attorney, we need to go after the CI. So, one of two things happens in every such case. Either A, the prosecutor knows that the CI is integral to the case, and so they list the confidential informant as a witness. They may do it by name. They may do it directly because they don't care. They may do it by confidential informant. It depends. They may do it by number. The best way to do it is always
put CI.
Right, whatever. They could do it by number. They could do it by initials. They could actually give you the name knowing that they're going to disclose it because they have every intention of doing so. But the other thing that can happen, which routinely happens, is they don't list a CI. They don't even list C.I. They don't list CI number blank. And the reason they don't do it is because it's incumbent upon the defense attorney to move to disclose or compel disclosure of the confidential informant. So many a prosecutor will know, and the reason I'm bringing it up, you will understand right now, many a prosecutor knows that which is inevitably true. There are a lot of shitty lawyers out there in the defense bar. There are a lot of lawyers that don't do their job. So why should the prosecutor make it easy for you? If the defense attorney is not going to actually do their homework and litigate a motion to disclose the identity of a confidential source or a confidential informant, why should the prosecutor give it to you for nothing? And even if they make you, or even if you do file it, there's no guarantee you win because it's litigation. And the only rule of litigation is there's no rules. Anything can happen. There's no guaranteed result. Right. You can have a dumbass judge who says, no, I'm not ordering the state to disclose it. I find that there's no Sixth Amendment, problem here, and yada yada. Have a nice life.
Right. Because you remember, Mike, the defense has to prove. Now, this doesn't take away from what I said. I agree with everything you said. I don't like when prosecutors did that. We never did that when I was in the narcotics unit. We know, we especially narcotics prosecutors, we knew the law, to be honest with you. And this is no disrespect to anybody, but this is what we did 24/7. We knew the law better than the judges in that building. We know damn well if we're going to have to disclose the CI. I wouldn't give you his name. I would put CI, care of the state attorney's office.
Let me tell you right now, I have two open CI cases here in Dade County. They're in front of two different judges. They're both in the exact same posture in terms of There's been no disclosure of the CI, even though I have filed motions to compel disclosure of the CI in both cases. One of the judges says to the state attorney at our hearing, the state attorney says, Judge, I'm not going to disclose the CI because I don't need the CI to prove the case. Now, of course, the judge has access to the police report. She's, knows enough about the case to have an idea of it. And the judge says to the prosecutor, sir, I don't understand how you're going to prove your case after reading the A form without disclosing the CI. But you know what? It's your case, and I'm not here to tell you how to try it. So good luck to you, sir. Now, that's one judge who clearly understands the process.
And
I have another case.
Hold on. Don't bury the lead. Let's be fair. That judge is a former prosecutor, isn't she?
I'm not going to say one way or another because I don't want to expose the case or the judge. The other one is in front of another judge who it's virtually the identical situation. And this particular judge has no clue. His basic premise is whatever the state wants, the state gets. So, we have this dichotomy of what do you do when you've got a judge? Well, at the end of the day, you have to live with it as the defense. You have to look at your client and say, Mike, I'm going to do my job. I'm going to create my record. I'm going to make the motion. I can't control what the judge does. Unfortunately, we may wind up in a situation of an appeal.
And just so we're crystal clear, one of the reasons that Mike and I chose to do this show is that's not a disparaging comment on the other judge. It's just very complicated matters. It's extreme. Look, going back to the hypo you gave, where you're the confidential source goes in and does a couple of buys, then the UC, the undercover comes in with you. We get you out of the picture, and he buys. At trial, if we charged the buys that Michael made, we have to disclose Michael.
Right.
But if we don't, that cop who was present while Michael was making those buys can talk about those buys. He absolutely can talk about everything that he saw. Why? Because it's what's called inextricably intertwined evidence. We need the jury to understand what brought my detective to this drug dealer in the first place, and why is it that this drug dealer trusted my undercover officer to sell him drugs.
The flip side and the corollary to that is that as a defense attorney, I'm going to want to know all of that in advance. Now, I'm not a big proponent of depositions, but in this case, I'm going to take a deposition of the lead officer. I'm going to take a depo of this guy, and I'm going to ask him those questions. And when he starts to refuse to answer and tell me that he wants those questions certified, we're going to litigate them. And that's when we're going to get into this discussion, and I'm going to say to the judge, this is all, it is a shell game. It is a house of cards. The reality is this case doesn't exist but for the confidential source, and I need that person. I need to know how and why that person initially introduced this undercover to my client, because there may be an entrapment defense there.
And that's the
although
argument.
It's not likely, but that's the argument that ultimately we would make.
We could go down that rabbit hole too about what Michael would have to prove, what the state would have to make sure that Michael proved to get that CI. But the point is, I think the overarching point of this show is how complicated these things really are. They're much more complicated than people can imagine. And I never, ever, ever, ever criticize or come down on a judge or a colleague who, myself, Mike, how many times have you asked me questions about narcotics trafficking case? I'm going, wait a minute. Let me think about this. And I did this for almost 4 years. I know everything forwards and back. I've forgotten more about narcotics cases than I can remember. It's very, very complicated, and every little detail of the facts can change the judge's ruling.
Right. And by the way, the law changes regularly too.
All the time.
Because there's always new cases. And when courts start doing appeals and interpreting decisions of trial courts and reviewing case law and reviewing other prior holdings, sometimes those decisions change and cases get overruled and new precedent is set. So, just because it's established today doesn't mean it's going to be good tomorrow. So your lawyer also needs to be on top of the law.
Right. I want to touch on one other thing you said about depots. I agree with you, Mike. And for those of you who watch the shows, taking depositions of, let's say, law enforcement officers, especially in most cases, most of the times really does nothing. It doesn't help the defense at all. We all know what they're going to say. We've been doing this long enough. We know exactly what they're going to say. We've said this before, right, Mike? They're going to read right from their report.
Right off the police reports.
But I love taking narcotics depositions because when I take narcotics depositions, especially me personally, since I was in there, I was in the belly of the beast. I know questions that they would never ever hear. I'll tell you one quick story. Met a lieutenant in another department when I was a defense attorney. I never met this guy. He didn't know I was a narcotics prosecutor in the past. Comes in, he gives a depo. I start asking questions, and almost by the second or third question, Mike, this lieutenant just starts grinning from ear to ear. And basically, he knew exactly where I was going, and he knew that I had uncovered because he got to the scene late. Remember, lieutenants don't come to the scene initially. He got to the scene late, and he knew there were problems. But listen, he's a cop. Like you said, it's a defense attorney's position to figure these things out and find these things out. Long story short, when we finished the depot, we walked out, and he was waiting for me. As soon as I come outside, he says, "Who are you?" And I said, "What do you mean?" He starts laughing. He says, "Dude, I don't know who you are, but you know way too much about what was going on at the scene." So I ended up telling him what it was. And this was like 10 or 15 years ago. To this day, he always tells people if he ever got arrested, he'd want to hire me. I take those depots not because I'm going to ask what's in the police reports. I know they're going to tell me that. But when it comes to narcotics, I start asking questions that will let me know if I need to investigate more, because certain questions that I can ask. So I do like to take it on the narcotics ones and the economic crimes ones. Those are the two big ones that I worked in both units that depots definitely help.
Let's pick one of these movies or even TV shows. I mean, I don't want to discount The Sopranos because there were so many rats and confidential sources in The Sopranos.
You'd be on your own there. I didn't watch it.
However many seasons it was.
I did not watch The Sopranos. No, I know. I didn't see Game of Thrones either. I'm like a unicorn, my friend. I'm a unicorn. I didn't see The Sopranos.
No, I would not call you a unicorn. An aberration maybe, but not a unicorn. Well, let's take one that you did see. Let's I don't want to go with Goodfellas because it's too
saw Departed, saw
easy.
The Godfather, saw Serpico, Scarface, not Scarface, Carlito's Way.
Let's go with The Departed. Let's go with The Departed because I think it's interesting. Let's start with the main character, Frank Costello, because I think it's really interesting that and this is typical in narcotics cases, especially
in the Fed system, not us so much in the Fed system.
But even in state, they do this with some frequency. In the feds, it's almost routine. They allow people to continue conducting criminal activity for a period of time, knowingly and willfully, so that they can continue to extract and produce and procure and preserve more and more evidence so that when they do ultimately make their arrest, the case is a slam dunk. Because instead of one or two transactions, they've got 30.
Yes, I've seen it, and I've had cases like that in the feds. I never saw that when I was in narcotics. We did not do that because our confidential informants had to testify. Now, a confidential source we may have suspected was up to no good, but if they gave us good info, we might still take it because remember, the cop still has to independently corroborate, but not a confidential informant. We couldn't risk it. We wouldn't take guys that we thought were violent.
That brings up one more thing. Let me just sidetrack from The Departed for a moment. One of the things that as a defense attorney, we know that maybe not so much prosecutors, but the cops have to think about is the value of their CI. Because there's a lot of CIs that are just like, one-hit wonders. They come in, they do one thing, and that's the only thing they're ever going to do. But there are other CIs that are exceedingly valuable to law enforcement because they're not one-timers. They're multi-timers. And
every
long
narcotics unit is looking for that guy.
So they have long tentacles. And the last thing they want to do is burn a guy like that by having to turn him over. So a smart, sophisticated, worldly experienced, skilled defense attorney, that's where we start as our focal point.
Absolutely.
How valuable is this guy? Because all of these trafficking cases come with minimum mandatory terms of imprisonment plus 30-year sentences. So the stakes are very high in any trafficking case. I don't care what it is. It could even be pot. It doesn't matter. Trafficking is trafficking. So if you have a min man and you're looking at 30 years on the high end just with that one count, you need to be sure that the prosecutor is willing to burn that CI. Because if they're not, and I'll give you an example right now, one of my cases, it was a task force between state and federal. And it's written right there in the A form. The case after the arrest was made, it went state because they expected to be able to do more, but they could only do so much, and it didn't reach the threshold that gets the feds all hot and bothered. So they simply handed it off to the state for prosecution. Problem is, they can't prove the case without the CI, and the CI is a federal CI. So now the pickle play is, in order for the state to go forward on that case, they have to overcome our Sixth Amendment right to confront the confidential source. Then they've got to get the feds to turn over that confidential source and allow him to come testify. Yep. And that is a very, very, very difficult task for a local prosecutor, especially with a fed.
That's one of the things that when I was in the narcotics unit, it did happen often because in our level, we don't have too many of those CIs, but occasionally we had CIs that were really good CIs that gave us a lot of big cases. And we would list, let's say he was a witness in the case. We would list him as a witness and we would simply put C.I., CI, no name, care of the state
attorney's office.
And what we were doing, Mike, is we wanted to see what defense attorney he got. That's right. I mean, I'm being honest. Brutally honest. If he got a defense attorney who pushed and pushed and pushed and pushed, we would play that game.
Then as a prosecutor, you needed to make that determination with your cops. Are we going to burn this guy, or are we going to dump this case and offer him probation and get rid of him?
It was a poker game. Let's see who's going to blink first. And then eventually, if the defense attorney, and look, after being there for a while, I knew who the guys were, right? So my officers would come in and I would call them in and say, listen, they hired X, Y, and Z. I'm not going to say who. Let's say, hey, listen, they hired Haber. So what does that mean? Dude, Haber's he's going to be a pain in the ass. He's going to push until we give the CI. So I want to know right now, can we disclose this guy or not? Because I'm not wasting time. I know Haber. I've worked against him in many times. He's not going to stop. He knows how the game's played. Can we disclose him? No, man, the guy's really good. Okay, fuck it. What am I going to give him? That's what the good experienced prosecutors would do. If we saw that it was a guy that wasn't going to push, I wouldn't even call him in because I know this guy's not going to push. Sooner or later, this defense attorney is going to make his client take a plea.
So sometimes we have to run this thing right down to the wire. And you just, as a defense attorney, you push, you concede nothing, you surrender nothing, you stipulate to nothing, you demand that the state prove everything, and you push that case right up to the jury sitting outside of the courtroom. The truth is, you got to be committed and you got to be prepared to roll the dice.
Well,
but if you know the rules and you got the facts,
it's like that's what I was saying. It's like a poker game. If you know you've got a good hand, if you know that the state needs that CI to prove the case, you got to push. And if the prosecutor doesn't see that you know what you're doing, then I blame the prosecutor. Even when I was in the office, I'd hear someone complain. I'd say, well, listen, man, I don't know what to tell you. I blame you. You know this guy. You know he's going to push. You know you can't prove it with the CI. Why are you fucking wasting time? Why are we playing these stupid games? Just work it out.
Let's go back for the last couple of moments and just finish up on The Departed. So we've got Costello. He's the mob guy. Again, he's a federal informant, and they're giving him a lot of free rein to continue his activities. Nobody knows he's a federal informant. He keeps that to himself. Everybody just thinks he's the major mob guy, but he's really a rat, right? Now let's go to the next guy. Let's go to Matt Damon's character, Colin Sullivan, right? So this is something that you never see, or well, I guess rarely see.
I think that was a little bit of poetic license.
You've got a guy who grew up under the umbrella of a mobster and went to the police academy to become a internal snitch against the cops back to the mob guy. It's genius, right? You keep him clean, you send him to school, you make sure he goes to church. He never gets arrested for anything on paper. He's the cleanest guy in the world, but he's an unbelievable source of information back to the mob guy so that the mob guy knows when the police are on to him, when they have information. You can give them information that steers them in a different direction. So if you know that mob guy is going to be doing a transaction at the docks, you steer them over to the railroad tracks, right?
Right.
And then you got the third guy, which we see regularly, and that's the undercover. That's DiCaprio's character. So you have an undercover officer. This happens all the time. I mean, this is
Correct.
vice cops
all the time.
So these are the guys that you like Ed said when we started this show. Nobody's going to sell Ed a kilo of cocaine because he don't look like the type of guy who would be buying a kilo of cocaine. But guess what? There's plenty of people who do look that role. And so those guys wind up becoming like Frank Serpico, right? Remember in that movie in the 70s, they kept saying to him, get a haircut, put on a uniform. And he's like, why? I'm an undercover guy. You know, right. I'm no good to anybody if I put on a uniform and get a haircut. So it's very interesting. And if you look at those movies, you'll get an idea. And The Sopranos, again, you know, Ed, you just got to bite the bullet and watch it because it's well worth your time. In fact, I don't think you can get into heaven if you haven't watched it. So I'm not sure about that, but I've been told. Listen, we're a minute over. I wish that we had more time because it really is such a fabulous subject and there's so much to talk about here. And we could actually probably do a full show just on The Departed. And maybe we will, or one of the other movies.
And you missed my favorite character of The Departed, which is Mark Wahlberg's character. I love that guy.
Right, but we don't know what his deal is because that guy could have been anything, right? He could have been working for Frank Costello for all we know.
Yeah, right? I think he was. But anyway, that's a story for another time. Point is, it's very complex. Listen, when I was in narcotics, I'll again let you go on this. I routinely in the 3 years that I was there, 2.5, 3 years, whatever I was there, I would go to seminars, law enforcement seminars that would last 2 days on just CIs and how we use them and what to do with them. And it's a very complicated matter and it's very interesting. So, but yeah, there's ways to get around it, and snitches are valuable to law enforcement, and the law allows them to do it.
If you do wind up in a situation where you have this type of a charge, or you know someone who has this type of a charge, hire a trafficking, not a traffic lawyer. You need to hire a lawyer who has some experience with these matters, understands the rules, the practicalities, the protocols, the procedures, the pitfalls, the pluses, the minuses. That's what you really need working on your behalf. Anyhow, I want to thank you guys for tuning in today to episode 40. Ed, thank you for coming. It was great.
Thank you.
Really appreciate it. And we will catch you all next week for episode number 41. I think next week. Do I have a trial? No, I'm good. Hopefully
I think I'm pretty good next week. I'm not sure. I'm pretty sure. I got a bunch of trials coming up, but I'm good.
You and me both, but I don't think I have the first one until 6/6. So we're just in prep mode. And by the way, that's going to be a trafficking case with a confidential informant. So we'll see what happens.
Yeah, maybe I'll pop my head in
June. All right, everybody. Thank you again. We look forward to seeing you again and being at your service next week. Take care, y'all.
Okay. Bye-bye.